There we are.
Okay,
Yeah.
I'd like to welcome everybody to the Senior Center's Zoom coffee chat that we do every Friday. And today our guest speaker is, there we go, sorry. Oh gosh, is Angela Clark, and she's a local attorney in Lenore, and she has come to join us to talk about estate wills. And we will have a question and answer session at the end. So, Angela, I'll turn it over to you.
Thank you so much. For folks that know me, I just go by Angie. My formal name is Angela, but I'm Angie Clark. I have an office here in Lenore, and part of the focus of my practice is helping folks do estate planning work, and that includes wills as well as powers of attorney, healthcare's power of attorney, living wills, things like that, and planning for Medicaid. I also assist folks after a death with the probate part, dealing with the estate office and trying to handle making sure the estate's taken care of. I do a few other odds and ends things at my practice as well. We are Lenore, so it is kind of small, but I was asked today to talk to you all about wills and the importance of having a will, what happens if you don't have a will, what are the laws in North Carolina as it pertains to wills, and at the end, of course, as Ingrid mentioned, I'll be glad to take any questions. I guess since especially it's going to be on YouTube, I do want to put a disclaimer that especially as to the questions, my answering your question does not form any type of attorney-client relationship with you. You would have to come in and meet with me. I'm just going to do general questions. If you have a specific question about your situation and it's fact-specific, I would prefer if you would make a phone consultation with me or something like that so we can discuss it. But in terms of general questions, I'll be glad to answer those for you. I'm gonna do my best to make sure I don't answer any of them incorrectly. But as far as a will, so in North Carolina, a will is a document, a legal document that indicates to your heirs and your beneficiaries after your death, primarily the focus is to designate how you want your property divided at your death, who you want your estate to go to. And our will can contain other things, but that's the primary goal of a will. And I'll get into some more detail in a minute about what is covered under a will, what types of assets are actually controlled by a will and what we say pass under a will. And there are some other assets that you may own that actually will not go through your estate. They are not controlled by your will. They're controlled by other laws, and we'll talk about those as well. But a will is a document that any person over the age of 18 or 18 or over may create. So minors are not allowed to create wills. And it's pretty simple in terms of who is allowed to create a will. If you're over 18 and you are of sound mind, the statute says sound mind. What that means is that it's presumed that you have the capacity, the mental capacity to be able to create a will. And throughout the years, there have been cases that have gone up to appellate courts to determine exactly what does that mean, having sound mind. Because I know, especially as folks get older, there comes a time when they may start forgetting things, may be diagnosed with dementia, and that can progressively get worse. And so there actually does come a point in time for some people when they may not have the capacity to be able to create a will because they may not have that sound mind. But in North Carolina, that basically means that a person knows what their property is. They know what kind of property they have. They know the nature of that property and the extent of that property. They also know what individuals would naturally take. Typically, that means your spouse or your children or other close heirs. If a person doesn't remember that they have certain children or doesn't remember their spouse, then they're probably not going to have that capacity to be able to make a will. Sound mind also means that the person knows that what they are doing is making a will. They're not just having a conversation about their property, but they actually have the idea and the thought and the knowledge that I know what I'm doing. I'm making a will, and this is what I'm intending. And finally, they need to know what the effect or legal consequences that will have after their death. And so that's what our appellate courts have, how they have defined what sound mind means in order to be able to create a will. So there actually are in North Carolina several different types of wills that are recognized and are valid. And a will can transfer at death both personal property and real property. Personal property simply means the items that you own that aren't real estate. So real property means real estate like houses and land. But personal property is your bank accounts, it's your household goods, it's your cars and motorcycles and things like that. So a will can pass both types of property. Now, some of the wills I'm going to tell you about you may never have heard of, and there's a reason, and it's because I really don't recommend certain types of wills. But at least one of the wills we're going to talk about doesn't allow real property to pass under it. But the most common type of will, and the one that I do recommend that most people have if they're going to have a will, is what we call an attested written will. And what that means is that the document, the will, is written out. Typically that means typed out, but it doesn't exclude handwritten wills. But typically that will is written out, and it lays out everything that the person, which we call the testator is the person who writes a will. It lays out everything that they want to happen after their death. And they sign it. That's what attested means. It means that they have signed it, and it means that it has been attested or signed in front of two witnesses who are, we'll get into what qualifies to be a witness in a minute, but it means that they have signed that will in front of two witnesses, and those two witnesses have also signed that will. And that is the most common type of will, and that's the type of will that I recommend that people have. It's the least likely to be challenged. It's the least likely to be held to be not valid. Another type of will, which I have actually dealt with, and it has worked, although these wills typically come with their problems, is called a holographic will. Holographic will. Under North Carolina statute, a holographic will is defined as a will that's written entirely in the handwriting of the testator. And so that doesn't mean typed out. That means handwriting. That means the person that's creating the will actually uses their pen and paper, and they handwrite out exactly what they want. It has to be in their handwriting. It has to be signed by them with their name on it in their own handwriting, and it has to be found after their death among their testator's valuable papers or effects, or in a safe deposit box or other safe place where it was deposited, even given to a person for safekeeping. If you'll remember, think back to what I just told you about an attested will. The biggest difference that you're going to see here, not only does it have to be in the testator's handwriting, not typed, it also doesn't require witnesses. And so what I've seen in my practice before is a will, a holographic will. If a person knows that death is imminent, they don't have time to seek an attorney or to get it handwritten, to get it typed out and get the witnesses. They have, at the last minute of their death, really wrote it out and signed it. Like I said, those wills sometimes do have problems because they probably, or a lot of times, don't contain all the information that we need to know about how to handle their property after death. So I don't recommend them, but they are allowed under North Carolina law if they follow those rules. A third type of will, which I really don't recommend at all, it comes with lots of problems, but it is in the law. It's called a nuncupative will, and that is a will that's actually made orally. It's not in writing. You can already see the type of problems we may have with that. It's a will made orally by a person who is in their last sickness or imminent death, and they also don't survive that sickness or death. So in other words, they're literally on their deathbed, and immediately or very soon thereafter that they orally make this will, they actually do pass away. So it doesn't qualify if they think they're on their deathbed and they relay what they want to pass along orally. and then they later recover. So that doesn't count. So, and then finally, with the nuncopative will, just to let you know, it only will apply to personal property, not land and houses. So you can't pass your real property orally through an nuncopative will. And also you do still have to have two witnesses there to hear what your wishes are there on your deathbed. And the person making that still has to have the capacity. So even if they're on their deathbed, they still have to have that sound mind that I talked about earlier. And they have to let those witnesses know, I intend for this to be my oral will to pass along this personal property. Again, don't really recommend that. And I have in my practice over the last, how many years have I been practicing? 11 years. I've not had to deal with one of those, and I really wouldn't want to, because it's so fraught with the possibility that it's not a good will. So I don't recommend those, but I wanted to let you know that the law does recognize them in North Carolina. So those are the three types of wills. Now I'm going to really focus at this point on the one that I do think is the best choice of those, which is the attested written will, and kind of give you some information about that. So I said it has to be signed by two witnesses. It is recommended, although not required, that you also have a notary in addition to the two witnesses, and in addition to yourself if you're the one signing it. It's recommended that you have a notary public who can notarize the signatures of both the testator as well as the witnesses. And then in addition to just simply notarizing it, there is a specific paragraph or clause that the statute, the North Carolina statutes, lays out that says if there is a notary present and the notary can notarize the witnesses' signatures and the testator signatures and include this, and it's called self-proving clause. What that clause basically says, and you can look it up in the statute if you want to, and I can give you the citation here. If you're interested, it's North Carolina General Statute 31-11.6, and the statute itself actually has the language that needs to go in to make it self-proving. And what self-proving means simply is that after you die and your executor or your heirs turn in your will to be probated by the court system, the self-proving clause, if it's done correctly, means that your heirs or executor will not have to go locate those witnesses that signed the will in your presence, because they are notarized with this self-proving language. That may seem like not a big deal, but trust me, because I've had to deal with this before as well. If you don't have the notary and you don't have the self-proving language, or it's not correct, then you have to go find those witnesses who witnessed your will. And the older the will is, the harder that is to do. I just recently, or actually I'm still involved in handling an estate where the testator, the decedent, she had her will done in 1987, I think, and it was South Carolina. And it was not self-proving, and I had to try to track down the witnesses. One of them had already deceased, and then I, believe it or not, I found the other two, which is very difficult to do sometimes. And so I guess my point being, if you have a will that is not self-proving, your heirs are going to have to try to go find those witnesses, and that may be difficult to do. And if they can't find them, and they can't find anybody who knew them or can sign an affidavit as to the witness's handwriting, you may be stuck with a will that you can't probate. And that's kind of the point of having a will, is to make sure it gets probated, make sure that your directions get followed. And if your witnesses can't be located, there's a possibility that your will won't be accepted by the courts, and then your property will pass as if you didn't have a will. If in North Carolina, that's called intestate or intestacy, which just means you die without a will. And I'm going to talk about that too. But the self-proving clause, in my opinion, is very important. Now, I said that you had to have two witnesses in addition to yourself. The statute talks about what constitutes a competent witness, And it doesn't really have anything to do with sound mind, although that is important. You don't want a witness who doesn't know what they're witnessing. But it also has to do with whether or not they were allowed to be a witness to this will. And what we're normally talking about here are family members or people that are inheriting under the will. It is not a good idea to have your family members be your witnesses to your will, especially if they are inheriting something under your will. And that is because the statute says that although, let's just use an example, let's say you're married and your spouse is your witness, but you wanted to leave your spouse property. So if your spouse is one of your two witnesses, they are competent. They can say, yes, I witnessed my spouse sign this will, but by doing that, they are then excluded from taking under the will. They do not get to inherit. So if they're a witness, they don't get to inherit under the will. So they can still be a witness and we can still get your will probated, but they lose their share. And that's not what you wanted or what you intended. So don't use, my recommendation is definitely don't use somebody who is taking under the will. And in my opinion, it's actually better to have disinterested witnesses, witnesses that would not inherit from you in any which way. Now there have been occasions, and I've actually worked with these, where we did have what we call an interested witness, a witness who took under the will, but we were very fortunate because we actually had more than two. We had that witness, then we had another witness and then a notary who could actually serve as a witness. So we were able to get that will probated by excluding the witness that was conflicted out, and we're able to get that will probated, but that doesn't always happen. So it's better to take the high road and don't present that problem. One of the things that when I was speaking with Ingrid and April at the Senior Center, I do regular presentations there, at least I did before COVID. And one of the things, I always ask them, tell me what your seniors are asking for. What are they looking for? What are they wanting? And one of the things that they told me was that a lot of people are asking about, they want a will, but they don't believe that they can afford to go to an attorney to get one. They're on a fixed income. They don't think they have the means to do that. And so one of the reasons they asked me to do this is so that people could maybe do their own will. It is possible. I really don't recommend it. There's too many pitfalls and traps that you can fall into, which would then make it very, very difficult for your heirs after your death. And they could actually end up spending way more money trying to get things figured out than the money you would have spent on the front end if you had sought some legal counsel and being able to make sure your will's done correctly. So that's just my advice. I'm not saying you can't do your own will. You certainly can. But I don't think it costs maybe as much as what you might think it does, just to make sure it's done correctly. So I would recommend, if at all possible, to try to seek out some legal assistance to be able to make sure your will's done correctly. There's too many pitfalls. Let's see. So what is contained in a will? I said to you early on that typically the primary purpose of a will is to be able to tell people how you want your property distributed at your death. And so one of the things that's contained in a will is who you name as executor of your will, executor or personal representative. Some people like to use that language. And what this person's job is to make sure that after your death, they are the person that is in charge of making sure that your estate is handled appropriately and correctly. They are the person that has to go to the clerk's office and fill out the appropriate forms. They are the person that has to make sure all of your debts are paid after your death. They may be required to sell some of your property to generate some funds to be able to pay off debts or to be able to pay off some of the beneficiaries that you've named, and to make sure things are done correctly. So I do recommend that you name at least one executor. You can name co-executors, and you can have two people. I've actually seen a case with three, but I would just caution you, the more people you name to fill that role, the more complicated it's going to be, and the more chance you're going to have of people not being able to get along or agree on things, and that's just going to cause problems. So I typically will recommend just one, although I do quite a few that people want co-executors. But I forgot, I lost my train of thought there. Sorry about that. So your executor is going to make sure everything's done correctly. You can also, and I recommend naming a backup or a substitute executor in your will. That way, if the person you've named either predeceases you or is having some health problems or personal problems or just really doesn't feel comfortable at that time in their life and being able to handle that responsibility and that task, if you've named a substitute executor, then that person then can step into their shoes. If you don't name a substitute executor, or the possibility that your primary and your substitute either can't do it or won't do it, then it's going to be kind of a toss-up in the air as to then who's going to handle administering your will. Is it going to be another family member that kind of volunteers and steps forward, assuming that other heirs don't object to that? Or another option would be the court can appoint what's called a public administrator. And a public administrator typically is an attorney that is appointed by the court to probate the will and handle the debts and the assets. That is something that I do as well. And so I actually have, I think, 3 cases going right now where I've been named as a public administrator for different reasons, but I'm handling that estate for those folks. But you typically want to name somebody yourself, somebody you trust to be able to handle those assets. Speaking of trusting them, that kind of leads into my next point, which is most people that I deal with that come in to do wills, we talk about, how much do you trust your executor? Obviously, hopefully you're picking somebody that's trustworthy. But one of the things that you need to decide is whether or not you are going to require your executor to post a bond. What does that mean, post a bond? So post a bond means that your executor has to get bonded or there's a bond is a process through an insurance company. So basically they're getting insured that they are going to handle your estate appropriately. And if they do anything inappropriate, then the bond or the insurance company is going to reimburse those funds to the estate. Most of the people I deal with don't want to have their executor go through the process of getting bonded. It's not that big of a process, quite honestly, and the cost of it, it depends on the value of the assets in your estate. So the bond price is dependent upon how much you own at your death. But typically for most of the estates I've handled, we're roughly looking at $200 to $400. One of the ones that I'm bonded in is a pretty big estate, and my bond was like $1,300, I think, that I had to pay. Just a word of caution, 99% of the time, that's not an issue. However, there have been cases, and one of the ones I'm dealing with, in which the executor mishandled the funds, and now we're trying to figure out a way to get those funds back from that person so that the heirs can get their inheritance. So it can become a problem, but just a word of caution about that. So first, so you name the executor. And then another thing that you may want to put in your will, or you may not, is whether or not you want a monument at your grave, or you want anything specific about your funeral or your plot, or your if you want to be cremated, what you want to do with your ashes, that kind of thing. So directions about how to dispose of your body and how you want that handled. So some people want to put that information in a will. And if you say, I want my executor to put a monument, a gravestone up at my grave, then in order for them to finish your estate, they've got to do that. The clerk of court, who's the agency, that person that looks over the probate, is going to make sure that that's done. Typically, there's a paragraph in the will that says that I direct that all my debts be paid out of the assets before any inheritance is given out. And not only is that something that most people put, it's actually the law under North Carolina. Any claims that have been filed against the estate for debts that the decedent owed are going to have to be paid before anybody can inherit any of your money. Then, of course, the main paragraph, or the big paragraph, is what you want to happen. Who do you want your property to go to? And there's as many ways to word that as there are people. And people sometimes are worried that, hey, I'm is this okay? Or is this normal? Or should I do this? And my answer is always, there's no right or wrong answer. This is your property. It's up to you how you want to distribute your property to your death. If you want to make it equal among your children, that's fine. If you want to make it unequal among your children, that's fine too. If you want to leave a specific child out because you have a reason for that, that's fine too. But all those things really need to be spelled out in your will. There's no right or wrong way. It's your property. You decide what you want to do with it. It doesn't have to go to children. If you want your property to go to a charity, or if you want your property to go to nieces and nephews or grandchildren or your friend or your neighbor, you certainly have the right to describe how you want your property divided. It can be, you can list a certain amount of money, like I want, $200 to go to my neighbor, or you can say, I want my estate divided in thirds, and 1/3 go to this person and 1/3 go to that person. You can do a combination of things. So really, it really boils down to what is it you want to happen to your property, who do you want to see it go to, and then we need to make it worded such that your wishes are clear and that's what happens. And when I say clear, that's where problems I've seen in the past have come in, is sometimes that paragraph or that section of the will is not clear. It's ambiguous. Sometimes it's just, it doesn't make any sense as to what it is you're wanting, and nobody can figure it out. And if we run into that problem, trying to figure out what you meant by your will, it very well may be that we have to go to court to get a judge to issue an order saying what that judge feels that you meant. And I've had to do this before. It's not fun. Trust me, it's not fun for your executor. It's not fun for your heirs, and it only causes problems, because typically you have this person or this group of people thinking, oh, I know for sure what she meant or he meant, they meant this. And then you have the other group of people that says, oh, no, they really meant this. And so then you, like I said, you have to go to court over it. And that's probably the last thing that you want to happen, is your loved ones fighting amongst themselves because it's not clear. So making sure things are crystal clear as to what it is you're wanting. Some examples, just to the problems that I've seen with that. So I've seen where people have listed an address. I want my house at this address to go to this person. Well, at that address, in addition to a house, there's also a mobile home. So does the mobile home also go to that person? Because you didn't say, I want the mobile home to go to somebody else. So where does it go? Or I've seen where a person had 2 deeds. So one deed had their house and their land, and they had another deed for the property next door that just had land. And so they said, I want my property, that's the way they said it, I want my property at such and such address to go to this person. Well, did you mean for that adjoining piece of property to go or not? And we had to go to court to find out what the judge said on that one. So just being clear, and you need to know too that the more detailed you get in terms of listing items, and I'm not really referring to real property here. Real property is important to list it out by its address, or even better by its parcel ID number that's with the tax office, or the deed and book and page with the Register of Deeds. I mean, the more specific on real estate you can get, the better. But with personal property, one thing I need to point out is, if you're going to, make a list of every little tiny item in your house that you want to go to somebody, that's first of all going to make your will very, very long. Not to say that it's wrong, but then you run the risk too of that property, that specific item not being found at your death. So if you say, I leave my bicycle to my grandson, and when you die, nobody can find a bicycle, and your grandson gets nothing. That paragraph is just kind of tossed out, and it's not given any effect. So just keep that in mind. That doesn't necessarily mean you have to go redo your will every time, but keep in mind, what is your goal, and do you want to make sure that at your death your goals are met? Having said that, though, it is a good idea to have a look at your wills and revisit them to make sure every 3 to 5 years, or if you have a major life event happen where you have, if there's a new child that's born, whether that be your child or a grandchild, whether that is somebody who's passed away, somebody's got married, and if those things change the way you want your property distributed, then you probably need to have another look at your will and see if you need to have it revised. I've seen, I'm dealing with another one right now. I've got so many horror stories I can tell you. I'm dealing with another one right now where a person did a will in 2006. They were married to one person. They had no children. But since that time, their previous spouse died. They married somebody else. They had more children. And there's no new will. And it just creates all sorts of problems. So just revisiting your will, making sure it's up to date is important. Lost wills. So obviously, if somebody can't find your will at your death, then your will's not going to be honored because they can't find it. It's lost. And so it's important to make sure that you keep your will in a safe place. One place that this differs from county to county. It is in the statute in North Carolina, but I have found through practice that some counties are choosing not to do this, and I'm not sure they can, but they do. Caldwell County does honor this, though. But what I recommend is you consider placing your will for safekeeping at the clerk of court's office in the county where you reside. That's where it will have to be probated anyway, and they will keep it for you free of charge. For safekeeping. It is kept in, it is not public information, is not accessible to the public. No one can go look at it. And it is kept in a fireproof, safe place for your executor to be able to find it after your death. Only caveat I say about that is if you move or if you do a new will, please make sure you go get your old one back out. You are allowed to go to the clerk's office and retrieve your old will. They will give it to you with your ID. They won't give it to anybody else. But don't just leave an old one there if you have a new one out there floating around. And that goes for wherever you store your will, even if you don't store it at the clerk's office. If you have a will and you decide later on to revise it, please, please, please find your original old will and destroy it. And also, if for any reason you have copies out there, to find those and destroy those as well. What you don't want is two wills out there floating around and your heirs trying to figure out, which one to use. And you also don't want an old will floating and a new will not being found, and then your old will having to be probated, because that doesn't reflect what you want to happen. So I do not really recommend a safe deposit box, although that seems contradictory because it's a pretty safe place at the bank. Because if you are the only person that has access to that safe deposit box, you are the only person on the lease with the bank, and it's in your name only, then no one after your death is going to be able to go to the bank and get your safe deposit box open unless they go through a process to where they have to get the clerk of court's office to meet you at the bank and get that lock drilled out by the bank. So it's a pain. If though you do have joint owners on that safe deposit box, if you have somebody else listed that does have access to that, then that may be an okay place to store it. A lot of people tell me that they keep their wills in their home in a safe that they have in their home, a fireproof safe. That's a good idea. Make sure whoever needs to get to it knows how to get into your safe. Again, hopefully it's somebody you trust, so you've been able to give them the combination, or you tell them where they can find it after your death or something like that. Some people actually feel more comfortable giving their will to their executor or personal representative for safekeeping. That's fine too. Just be aware, if you give it to somebody to hold, you can't control whether they get nosy and decide to look at it or not, or maybe you don't care. But make sure they keep it in a safe place, because you don't want to risk them losing it either. So just make sure it's safe and make sure it can be found. I've had a situation where a man came in and he knew, as a matter of fact, I think I'm the one that drafted his wife's will. It was a second marriage situation, and she wanted to take her will home with her for safekeeping, and she did. And after her death, her husband could not find it. And so we had a problem with that, because we had no will to go on, and the property did not pass the way she wanted it to pass. So making sure it's safe is important. So I told you that in North Carolina, if you die without a will, the law is going to take over. The statute provides for what happens to your property if you don't have a will. And the same thing is going to happen if your will is deemed to be not valid. So even if you do have a will, but you didn't get the witnesses right on it, or we can't find the witnesses, or you screwed up something in the will and it's not valid. In that case, property is going to pass as if you didn't have a will. And in North Carolina, there's a whole statute on that, and there's a lot of it depends. So what happens to it? Some people have the misguided belief that automatically, if you die without a will, your property goes to the state, but that's not true. Typically, what the hierarchy is first they look to a spouse. Is there a surviving spouse? If so, then they look to see, are there children also? And it will depend on how many children there are, and then the statute spells out how much property the spouse gets, how much property the children get. If there's no spouse, they look to children, or grandchildren, people in that lineage. If there's none of those, they look to parents. If there's no parents, they start looking to brothers and sisters. If there's no brothers and sisters, they start looking to nieces and nephews. And so it kind of spreads out and goes from there. And so the idea being, they're going to try to give it to the natural members of your family in a certain order. If you have no members of a family, or none can be located, and there is nobody to give your property to under statute, in that case, it does a sheet to the state, which just means the property then goes into the state treasury until and unless somebody with proper identification can claim it. And you certainly don't want that to happen to your property. So that's another reason a will is important. But if you don't have one and you have family, the property is going to pass to your family according to the way the statute's written. Or if your will is not valid, that's the way your property is going to pass, even if that's not how you wanted it to work. Let's see, what else do I need to tell you? I've gone through my notes pretty quickly, and I think we've got a little bit of time. Maybe, Ingrid, if we can maybe open it up for questions, and that might lead to a discussion to fill some more. I don't want to get shortchanged, but I want to make time for questions.
Okay. Did anybody have a question? You'll need to unmute.
Yes, ma'am. At the beginning, you said if it was anything of a personal nature, we probably need to speak to you in person. Can I have your phone number so I can call you and set up an appointment?
Sure. My telephone number at the office is area code 828-754-4266.
754-4266?
Yes, ma'am.
Okay.
My office is located in downtown Lenoir, diagonally across from the post office. The address for my office is 205 Ridge Street Northwest, and that's Lenoir.
Angie, I sent you a question privately. Can you read it on the chat?
Maybe on the chat, on the Zoom thing?
Yes.
Oh, well, you're testing my my abilities here. Let's see.
Just go over to the upper right corner.
Okay, I see it. Oh, thank you, because that leads to a whole set of information that I forgot to mention. Do you mind if I read your question, or?
No, that's fine.
Okay, the question was, if the property is held jointly, does it go through probate? And I completely forgot to bring this out, so I appreciate you asking that question. So remember, I mentioned at the first part of the presentation that sometimes there's property that doesn't pass under your will, or it doesn't go through probate. And so that's property that is held jointly with another person or a beneficiary. So let me give you some examples of property that does not pass under a will, go through probate. One type of property is, this most often applies to land and houses, it also most often applies to joint bank accounts, and can apply to jointly owned vehicles in North Carolina if you set it up that way. And what I'm talking about is a special type of ownership. It's joint with right of survivorship, or for married couples and you're dealing with land, real property, it can be tenancy by the entireties, which just means you own it as a married couple. And in those cases, the property does not go through probate. It goes directly, it is paid directly to the other joint owner. So if you're married and you own your land and house as a married couple and one spouse dies, it automatically is owned by the other spouse. The will, it doesn't matter what you put in your will, it's not going to make any difference. Your spouse automatically owns that property. If you have joint bank accounts at your bank, the default position for most banks is if you make a joint bank account, it is joint with right of survivorship. And right of survivorship is the key, because that says at your death, your survivor joint owner now owns it. There can be joint accounts that does not have right of survivorship, but typically if you're talking about a bank, you have to specify that to your banker. They're going to, when you open up an account at the bank, you may or may not remember this, but you have to sign this document. It's called a signature card. And that card specifies the legal rights of any joint owners as to whether or not they get to have the money at your death. Like I said, that's the default position for most banks. But if you don't want it that way, you need to make sure to let them know. Also, in North Carolina, if you specify and you own a vehicle with typically it's with your spouse, I guess technically, yes, you can do it with other people. You can ask DMV to make sure that your title to your vehicle is set up with joint with right of survivorship. And if that happens at your death, that vehicle automatically belongs to that other joint owner, and it does not go through your will. It does not become part of probate. Another way that you can have property that's not part of your will is beneficiaries. So for example, if you have a life insurance policy and you name a beneficiary with your life insurance company, then that life insurance policy is going to pay out directly to whoever you named as beneficiary, and it does not come through your will. It does not pass through the estate. I recommend that you do. For most people, it's good to have a beneficiary. There are some situations when I would recommend something different, but for most people, I recommend having a beneficiary and actually having a contingent beneficiary too. And that is, if something happens to your primary beneficiary, who would you want it to go to? And you can name multiple people. So you can say, for example, one of the most common setups I've seen is my beneficiary of my life insurance is my spouse. But if my spouse dies before me, then I want my life insurance to go to my children equally. And you can set it up that way, and the money goes straight to them. Same thing if you have an IRA or a 401k or an investment account. You can set up those accounts to have beneficiaries and contingent beneficiaries. And if you do, those funds or those assets will pass directly to those folks, and it doesn't go through the probate process. And that can be beneficial in lots of other ways as well, because any property that doesn't go through probate doesn't have to be used to pay debts. And that there's another hour-long topic on why you might want to do that. But great question. I apologize, I forgot to mention that. But yes, there's property that doesn't pass. Also, talking about bank accounts, it reminded me there's other types of bank accounts. You can have what they call it different things. I've seen a POA account where a person is a power of attorney has a power of attorney over somebody, and they're on their bank account for the purpose of helping them write checks, but they don't own it. And that will go through a will. That property does pass through a will. There's also, some banks call it POD, payable on death. Some banks say TOD, transfer on death, means the same thing. And those are accounts that are set up. That basically is set up like a beneficiary. It means that during your lifetime, they don't have any ownership of that account, but at your death, it's payable to them on your death. So like a beneficiary. So you can set up bank accounts that way as well. So great question.
You have to specifically say right of survivor, or can it just be two people on there?
No, it depends on what you're talking about. If you're talking about land or a bank account, but it really does need to say right of survivorship. And if you're talking about the bank, that wording, right of survivorship, is on that signature card. It may not be on the checks, it may not be on the bank statement, but what the court's going to look for is that, and they're going to ask for it at the death of that person, is you've got to go to the bank and get a copy of that signature card, that card that was signed, that piece of paper that was signed when the account was opened, and it will say whether or not it has right of survivorship. That language will be there. Doesn't matter what's on the checks or the statement. As far as land, unless you own it as husband and wife and you own it with somebody else, yes, in order for it to pass directly to them, yes, it has to say right of survivorship on that deed. If it doesn't, then you are, and you own it with somebody other than a spouse, and it doesn't say right of survivorship, then you're owning it as co-tenants, meaning that you each own, if there's two co-tenants, you each own half, and the other person doesn't automatically inherit it.
What's the financial charge that probate charges?
There are different kinds of estates. So the charges are different, but for most people, if they have to open what we say a full probate or a full estate, the filing fee to open it is $120. And then you have to run a creditor's notice in the newspaper, and that the newspaper charges you for that. And that average for that is around, at least in Caldwell County, is around $250 to $300. Other newspapers in other counties, different rates. Then you have to pay a fee at what we call the inventory, 90-day inventory or 90-day accounting. That fee is based on the value of your personal property, and it's 40 cents for every $100 of assets that you own. So, and with a minimum fee of $15, and then there is a maximum, but it's beyond most people's assets. And then there has to be another fee paid again at the closing, at the final accounting. Sometimes, typically estates are open and closed within a year's period of time, but if they're not, if for whatever reason you have to keep the estate open longer than a year, you have to do annual accountings, and there's fees that have to be paid then too, minimum of $15, but again, it's based on the assets that have come into the estate over that last year. So that's the fees that the court charges. Sometimes executors or personal representatives don't feel comfortable being able to handle all this by themselves, and sometimes they retain an attorney to help them do this, and if so, then of course you've got attorney's fees as well.
I have a question on that, what you just said about attorney's fees. Let's say you had set up your will with an attorney and named the attorney to settle the estate rather than a family member. But I'm throwing out, if a person maybe had to go into a nursing home long-term and all their assets were used up, how would you go about settling the estate if there wasn't money for the attorney?
Well, sometimes that actually happens, and there aren't assets in the estate to be able to pay. And so, in those cases, there may not even be an estate to probate. So there may, if there's no assets whatsoever, then there's really no estate to probate at all. Estate administration fees come out first. If you've named an attorney or anybody else, an executor or personal representative, you can put in your will how much you want them to be paid to do that job. It's called commissions, and you can designate a certain amount, a certain percentage. If you don't put a certain percentage or amount in your will, the statute says that the clerk can authorize up to 5% of all the assets and all the debts that have been paid to be payment for the personal representative, and even if that's an attorney. So, for example, in those estates that I'm the personal or the public administrator, I'm paid not for attorney's fees, I'm paid a commission, just like any personal representative would be. But, even if there are some assets, if you've named an attorney and the estate has a few assets but not a lot, and the attorney feels like there's not going to be enough that make it worth their time, they probably will decline to take that job on. And I've seen that happen, not just with attorneys, but I've seen people say, you know what, I don't want to deal with it.
And in that case, then, does some extended family are responsible to settle this, or how is that? That's really my question. How would that
Okay,
be?
if whoever's name declines to serve, then yes, a family member can ask to be named and take over that job, and they have to be approved by the court. There's a process that's involved with that. But if nobody steps up and there is an estate to administer, that's when the clerk would appoint a public administrator to do it.
Okay. So it could be taken care of that way if no one in the family felt that they could handle that situation.
Mm-hmm.
That's very helpful. Thank you.
Does anyone else have a question? I did want to ask you about if people are interested in coming to see you, do you have any COVID-19 related restrictions with what you're providing right now or anything?
So what I'm trying to do is as much phone consultations as possible, just to try to restrict and keep people as safe as possible, me and my staff, as well as the folks that are wanting to be my clients. So if that's possible, now I have had some situations where folks don't feel comfortable with the phone consultations, either because they have difficulty hearing or they would just feel more comfortable. And I am allowing folks to come in. We are requiring masks in our office, and our staff wears masks, and we ask our clients to do so as well. We also completely clean and sanitize all surfaces after any person leaves, just to try to make sure that we keep things as clean and sanitized as possible. We do that. We do doorknobs and countertops and the chairs and the table and everything. We also are providing pins for folks that they can keep and take with them, so we don't have to share those. So we are trying to be as safe as possible. When it comes time, so for example, if I do a phone consultation and talk to somebody and they want me to draft a document, I give them the choice that they can take because with a will, you have to have a witness, 2 witnesses, and typically a notary. So I give people the option of taking it with them and finding their own witness as a notary if they choose to, or I will accommodate them to come here and I provide my staff, and we have 3 notaries here. So I do provide that service. And so a lot of times people will do the phone conference, and then we schedule a face-to-face to actually go over it and do the signing.
Okay. Did anybody else have a question? We have about 5 minutes. We did great.
Yay!
Thank you so much.
Well, I do encourage folks to get a will, unless you're okay with the way the property is going to pass without it. And as Mary asking that question, if possible, and it's it matches your goals, it may be beneficial to set up as much as you can to pass outside of the will, so that you don't have to worry so much about the estate. And when I talk about Medicaid planning, some folks have heard that seminar before, and I'll probably do it again. There's some reasons to do that for Medicaid purposes, setting up your property so that it doesn't come through the estate. Because if you've had to go to a facility and you've had to have Medicaid, at your death, Medicaid is going to file a claim against your estate, and they're going to ask to be paid back. And they're going to have to be paid back before any of your heirs can inherit. So sometimes there's good reasons, in addition to not having to worry about going through probate and not having to pay some of those fees and costs. There's other reasons, such as the Medicaid issue.
You mentioned banks a lot, but do credit unions also have that right of survivorship on their cards?
Yes, they do.
Okay.
I had a quick question on North Carolina law, whether they have a beneficiary deed for real property in this state.
A beneficiary deed?
Yeah, we had that in Arizona where we used to live, and Washington State has that now where my mother lived.
No, there was actually some talk about that floating around on one of the listservs that I'm a member of, where there was some talk about North Carolina possibly trying to pass a law to do that. But as of right now, that has not passed.
Okay, thank you.
Mhm.
I had a question.
Go ahead.
What if your will was done out of state and you moved here? I think I know what the answer is, but somebody else might want to know.
No, that's a great question, and I've had folks ask me that. I would recommend, if your will is done out of state, that you have an attorney look at it to see if it's going to be valid here. I have probated wills from out of state and not had any issues. So I would just say, get somebody that knows what they're doing to look at it to see if it's going to work here. As far as other documents like powers of attorney and healthcare powers of attorney, I actually recommend that you redo those in your new state so you don't run into issues from having those kind of documents in another state. Wills are a little different. If you can prove that the will was valid in the state that it was drafted in, then it can be admitted into probate here. And I've had to do that. One time I had a West Virginia will that didn't have the same information that North Carolina wills, but I was able to go and find, I had to do some research and find the West Virginia law to show that it was valid in West Virginia at the time it was drafted and signed, and therefore it was valid here. So we were able to get that probated. So, you know, I'm not going to say, yes, you need to go get a new will. Now, there may be other reasons why you need a new will anyway. Things may have changed, your circumstances, and you may want your property to go differently, in which case it's probably a better idea to go ahead and get a new one. But wills don't expire. You know, they don't expire, and just because they're in another state doesn't mean they won't work here.
And how about executors? That executors can be residents of another state?
Executors can be residents of other states. That makes it difficult, obviously, for them to try to deal with handling things here. Is a lot of traveling back and forth or hiring an attorney to help you. If you are an out-of-state resident and you are named as an executor, you have to ask someone within the borders of the state to be your, what we call process agent, resident process agent. And that just means that for purposes of if any documents need to be served on someone, the court needs to have jurisdiction over somebody within the state borders. And so if you live out of state, you can ask someone, a neighbor, a friend, a relative, an attorney. I've done it for people before when they've hired me to help them with the estate. I've been their resident process agent. Just means I'm available to be served with documents instead of having to serve them out of state. Mm-hmm.
Okay, thank you.
Mm-hmm, you're welcome.
I have a quick question. If you're doing like a phone consultation, what would be like a estimate of a cost for the phone consultation if you're starting out?
From at my office, I know attorneys set their own rates, and I know some are maybe a little more, a little less, but in my office, I charge $150 for a consultation, and that's whether it's in person or on the phone. And that typically is up to an hour of time for a consultation. And for estate planning purposes, we usually use most of that hour because there's a lot to talk about.
Yes.
Anybody else? I don't want to keep Angie. I know she has lots of stuff to do today.
Not at $150 an hour, you know.
I don't know.
I'm going to put a GoFundMe. No, I'm just teasing.
There you go. Thank you so much for this great information. We really appreciate you coming on today, and we'll talk to you soon, maybe about another program. We appreciate it.
Sure.
And
Sure, I'll be happy to.
Thank you so much.
All right, you're welcome. Everybody have a great day.
You
Bye-bye.
too.
Thank you.
Bye.